Avoiding legal conflicts when appointing and removing corporate officers. Part of the series, Global Business Law in 20 Minutes with Federico Vasoli. That is our topic for today. Welcome to the Lawyers and Mediators International Show and Podcast by instantmediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcast. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent. Hey everyone, this is Mac Pierre-Louis, attorney, mediator, and arbitrator working throughout Florida and Texas.
And Natalia, Olowska-Czajka, advocate, mediator, and arbitrator from Warsaw, Poland.
And Federico Vasoli, lawyer originally from Italy, managing partner of the MTV Global with offices in Singapore, Vietnam, and Malta.
Hello, Federico, and welcome again. It's a great pleasure to have you with us after a while. And you are back into Vietnam, which is very exciting. And we want to hear from you today something more about the rules regarding appointing and dismissing all corporate officers. And if you could just briefly say which perspective you would want to adopt in our conversation, and then we'll move on.
Thank you very much, Natalia. Thank you, Mac. And thanks to everyone that is watching or listening to this podcast. It's been a while and it's great to be back. It's also good to be back in Vietnam. The perspective is comparative because I believe that the people that listen to us and watch our podcast on the various platforms are interested in learning more about the big picture and seeing what major differences there are in the jurisdictions that I personally cover. So the ones that I mentioned in my introduction, namely Singapore, Malta, and Vietnam. Particularly considering that, for instance, Vietnam has recently amended its company law, which is based on two pieces of legislation. One is the law on investment and one is the law on enterprises that govern, we talked about it in a previous episode, investments in this country. So it would be interesting to see if there are any similarities and differences and what foreign investors in particular should be interested and careful about when appointing and removing corporate officers, which are figures that are needed in most companies almost everywhere in the world.
Federico, please continue. So what are some of the basics when it comes to appointing or removing corporate officers? And can you give it to us from the perspective of Malta, Singapore, and Vietnam?
Well, first of all, we need to define what companies we're talking about. And my perspective is that of limited liability companies. So we're not considering joint stock companies or whatever equivalent you have in other jurisdictions, public companies as they may be called in various countries. We're not talking about listed companies. We're not talking about investment funds, even though investment funds are something that recently kept me busy. So we may have a talk about that in the future. So we're focusing on limited liability companies. That is the structures that every small entrepreneur, not necessarily small, but for sure, small ones, and even those that grow bigger, use to start with. Now, typically, a limited liability company will have a shareholders meeting. It is called in various names, even when translated into English. For instance, in the English translation from Vietnamese in Vietnam, it is called member council, but it is the same thing. It is the AGM, the annual general meeting. Meeting of whom? Meeting of the shareholders. So you have the shareholders. It could be one if you have a so-called uninominal limited liability company, which can be allowed in most countries. There are some jurisdictions, though, where a company, by definition, can be formed only if you have at least two shareholders. It is not the case in Singapore. It is not the case in Malta. It is not the case in Vietnam. So rest assured that if you want to open a company in any of these jurisdictions, whether you are a natural person or a company, you can open your limited liability company with just one shareholder. So you have your company in Poland, you have your company in Texas or in Florida, and that company wants to set up a company, say in Vietnam or in Malta or in Singapore, in any of these three jurisdictions, they don't need to have an additional shareholder. So the shares can be owned 100% by the shareholder. The same goes whether it is you individually as a natural person that wishes to do so. Caveat, in Vietnam, we talked about it in the episode about the reformed, about the amended law on enterprises and the amended law on investment. There are some so-called conditioned industries. What are conditioned industries? They are industries where foreigners can indeed invest, but they are conditioned. There are certain, there is a number of restrictions, of conditions that foreign investors must meet before investing in such industries. One of these conditions could be, it is not always the case, but it could be that you might need a local shareholder. So your Florida company, your natural person from Poland or whatever can come to Vietnam, invest here, but they need a Vietnamese legal entity or a Vietnamese natural person to open their company with. So the first thing is the shareholders, the owners. They are the ones that own the company and that get the profits in terms of dividends every now and then, normally every year. It could be at early stages if they want to get some so-called interim dividends. So this is the first figure, the shareholders. The shareholders meeting, called Member Council here in Vietnam, is the ultimate body, is the one that has all the power and that can retain the power and give powers to the other corporate officers. Then you typically have a director. The director is probably the most complicated figure because the director or directors, when you have a board, usually are the people that manage the company on a daily basis. So together with the managers, depends on how complicated your structure is and how heavy the organizational chart is. But the director or directors are the people who have a decision-making role, and therefore they are responsible for their actions. Typically, the shareholders are those that invest the money, that have an idea, and then they appoint somebody else, a director, a manager, to run the business. But it could well be, especially in smaller structures, that one or more shareholders are also directors of the company. So this is an important figure. And there are some significant differences in this case, and we can talk about them later, among Vietnam, Singapore, and Malta. And then sometimes you have auditors or inspectors. For instance, in Vietnam, we talk about in the English translation of the Vietnamese jargon, there are the members of the inspection committee. So that they are from 3 to 5 members that are appointed by the members' council. So they're not entirely independent. And essentially they have an overseeing role over what happens in the company, especially on the role of the director. In Malta, you have auditors. So they are independent professionals that go through the accounts of the company, and they check on the job of the director or directors, as well as on the job of the company secretaries and of the accountants. So this is the broadest picture that I can give you.
Federico, as we can see, there is quite a lot of people that you might need for that, although I understand you can also limit the number. However,
yes.
Tell us if there are any restrictions on a nationality, domicile of those people whom you appoint. This is especially important so that it doesn't create any conflict in terms of when you start your business and you can already conflict the local authorities about it.
Very good question, Natalia. So in most countries, you need people that are resident in that country. They don't necessarily need to be citizens of the country, but they need to live in the country where they operate and have a valid work permit or residency permit. For instance, in Singapore, the director of the company, if there is a sole director, must be either a Singaporean citizen or a Singaporean permanent resident. A permanent resident is somebody that is not a Singaporean citizen by definition, but resides permanently in Vietnam. So it is somebody that has been vetted by the government of Singapore and qualifies as somebody that meets all the requirements for living permanently in Singapore. In Malta, it is not really necessary to have a director that is a resident of Malta, but it is highly advised. This is a general rule of thumb anywhere in the world, in order to prove that you have local substance. What is local substance? Local substance is having your office, your personnel, your activities, your whatever, including your director, that are located in the place where you run the business. And this is quite crucial, for instance, for opening a bank account. If you open a company in Malta and you don't even have a local director, it is quite difficult that a Maltese bank will open a bank account for your company. So you should have a local director. Now, having a local director doesn't mean that you are prevented from having non-resident directors. So in the case of Singapore, but even in Malta, of course, or Vietnam, you must or should have one local director, but you can have a board of directors where the other members of the board are not resident in Singapore, Malta, Vietnam, you name it. So one is the legal representative that is based there. He's the one that signs the papers in front of the authorities in that country that might appear in court or in arbitration when there is a legal case, or goes to the bank or goes before the notary, blah, blah, blah. But then you can have a board composed of people from all over the world. So this is quite important to consider. Now, one last thing before I give you before you can ask me more questions. There might be some tax consequences when it comes to this. So if you have a non-resident director in Singapore, for instance, if that director is remunerated, then his or her remuneration would be taxed at source in Singapore. So imagine you are in Poland, you're in America. You serve as a director in a company in Singapore. You are remunerated for that job. Now, Singapore will make you pay 20% of your income as a director directly when it is paid to you out of Singapore, plus whatever taxes you need to pay in America, in Poland, anywhere else in the world where you have to pay your taxes and file your returns. This is something that you should consider. For instance, you might want not to be paid as a director, not to receive a compensation for your role as director, but to receive instead shares and receive dividends that, at least in Singapore, are tax-free.
Federico, so what about if these corporate officers are a part of a labor contract, or should there be a labor contract when you're thinking about removing or appointing?
Very good question, Mac. So yes and no. That is, you don't necessarily need to employ them under a labor contract, especially in smaller structures, particularly when you are the shareholder and you're also acting as director. You definitely do not need a labor contract for third-party officers, such as the inspection committee in Vietnam or the auditors in Malta, because they are, in Malta, the auditors are professionals that meet certain qualifications. They need to be accountants, typically, sometimes lawyers, that work for an auditing company that is licensed to do so. So in that case, you have a service agreement. But indeed, you can have certain officers, for instance, here in Vietnam, the members of the inspection committee, and even some directors can be employed under a labor contract. Now, that is good and bad. It offers pros and cons, like most things. The pros are that the terms are better regulated of that position. The cons are, of course, that employees tend to be more protected than free professionals and free those that act as corporate officers simply as a random profession and not as employees, as free traders. So if you look at it from the perspective of the shareholders, it might be slightly more difficult to remove them and replace them with somebody else.
And knowing already how you can appoint these people, we are absolutely smoothly should go to the moment when you try to remove them, either by lapse of time for the term of office, or upon misconduct, or upon just the willingness to change those members. In my personal experience, this is where most conflicts arise. We had cases even in big companies here in Poland where we had people claiming that there were two simultaneously governing boards of officers, which of course can't be true and had to be judged by a court. So, what do you need in order to have it effective? And does it give any grounds to claims to these officers if they are removed?
One important, what you said is very insightful, Natalia. Thank you. One thing to consider is what happens after the dismissal. So even before you pose yourself the question of dismissing somebody, if you look at the situation in foresight, what happens when the company is left without any of these corporate officers? Now that depends on the jurisdiction, depends on the type of company, depends on the officer that you're removing and trying to replace. But I'll give you the example of Singapore, which is quite significant. In Singapore, a company cannot remain without a director. So the bare minimum is to have one director. Now, you may remove the director, but as long as you don't find a replacement, that same director, the same physical person, the same natural person will remain serving as director until the new one is found. So that could indeed create a lot of conflicts because the director that knows that is going to be replaced might not be cooperating that willingly with the shareholders, might be playing tricks and so on. So that is a problem. It is also a problem for the director himself or herself in that the director might want to resign, but he or she cannot resign until a replacement is found. So suppose the shareholder is not in good standing. By good standing, I mean that the shareholder has paid the directorship fees, and there are some issues with, I don't know, compliance with the law, whereby the director wishes to resign. So not necessarily is it a problem of being paid by the shareholder, but it could also be that the shareholder is behaving in a shady way, etc. So the director doesn't feel comfortable in serving in that position any longer. Now, if that is the case, the director finds himself or herself in a pretty tricky situation because, again, he cannot resign until somebody else is found. So typically, this is a practical piece of advice that I give to directors and a tip that I give to potential investors and shareholders. Typically, a professional director would ask for a fully refundable deposit upon setting up a company. In other words, when you set up a company in Singapore, you have to appoint a director. The director will cost you X every year. Now, when you set up the company, during year one, you will pay X times 2. That is the full year for the director plus another year in terms of security deposit. So the moment there is a problem with the director on either side, whether it is the shareholder or the director, that deposit could be retained by the director either as a compensation for his or her removal or as a security for the director himself or herself. So this is something that should be considered also in terms of cash flows, because evidently directors' fees tend to be one of the highest figures when managing a company in Singapore. So yeah, this is pretty much it about removing and replacing directors in Singapore. Something similar happens in other jurisdictions, but it is not as tricky. So for instance, here in Vietnam, you can replace them in a way, I would say, more easily than in Singapore.
Thank you for that. So, Federico, your title is Global Business Law in 20 minutes. So we're approaching 19 minutes. So to close, what would, if you were to give just one salient point on the most effective way, the most likely way that you would avoid conflicts, because that's always our theme on these episodes, what would you tell somebody putting yourself in their shoes if they are in a corporation on how to avoid conflict in this area of appointing and removing corporate officers?
To use your words, Mac, the one salient point would be choose your people carefully and make sure you're properly followed by somebody that knows the game, the rules of the game. Simple
Got
as
it.
that.
So pick your people wisely.
Yes.
All right. So with that, Natalia, please go ahead.
No, that is something that is absolutely impressive because that gives us almost 20 minutes. So, time to close up. And we thank you so much for being so succinct and for sharing your knowledge, especially this topic of double pay for and therefore having a deposit is actually quite an interesting legal topic and legal concept that can be spread elsewhere. Having said that, we're looking forward to having you again. And
Me
thank you
too.
for today. Bye
Thank
bye.
you, Natalia and Mac. Thank you all.
Till
Bye
next time.
bye.